The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like.
Imagine standing in court and suddenly learning your lawyer has been disbarred. No warning, no defense, just silence. What happens when justice forgets your name and your attorney disappears? This courtroom meltdown exposes what happens when the legal system collapses mid-trial and it all starts with one phone call that never got answered.
We will go on the record in the matters 23 CF 189, 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart in person with counsel Nicholas Davis. We're set here today in this matter for two things. One is for a status conference on 24 CF 163, and the other is for a sentencing hearing in 23 CF 189. Mr. Davis, can you please give me a status on the 24 matter before we proceed?
Your Honor, it's not resolved, but may I ask you for a little more patience? I think it has the potential to resolve. I just need another opportunity to speak with District Attorney Schmidt. I'm not asking for that 90-day mumbo jumbo. If I can just have 30 days, Judge, I'd appreciate it.
The courtroom was buzzing with confusion. Kutira stood silent, her attorney nowhere in sight. The clerk leaned forward. We've been trying to reach him, but then came the bombshell. Michael Patton, her lawyer, had been disbarred. The judge paused, disbelief shadowing his face. Disbarred in the middle of an open case. The silence in the courtroom thickened like fog. All eyes turned to Kutira, alone, abandoned, and blindsided. This wasn't just a scheduling issue. This was chaos.
All right, for that matter, all right. And we are in victims' rights compliance for that matter, yes. Okay. And are we in victims' rights compliance for the 23 case? Yes. Okay. Are we ready to proceed on the 23 matter?
Yes, Your Honor.
Okay. Well, with the 24 matter, Mr. Schmidt, Mr. Davis is asking for additional time to be able to negotiate with you to see if the matter can resolve or if we do need to set the matter for trial. I don't believe that we've had any type of speedy disposition request from either Mr. Stewart or from victims. I do know that victims would like to get the matter resolved as quickly as we can, but not, it hasn't been requested to get it done now, so to speak. So is an additional 30 days objected to?
No, and basically nobody wants to have trials where young children have to testify if they don't have to.
All right, so then that's fine with the 24 matter. So we can go ahead and get that set right now for an additional status and see where we're going to go with that. Mr. Davis, you are coming back on February 10th at 11:30. February 10th at 11:30. We can go ahead and set that at that time.
Yes, Your Honor. Thank you, Your Honor. Your Honor, Your Honor, and
date on that.
What?
I missed the date on that.
February 10th at 11:30.
February 10th.
Your Honor, those other two matters, you allow me to appear by Zoom. May I appear by Zoom for this, please?
You may.
Thank you.
Okay. Now,
Judge asked again, hoping this was some clerical error. Disbarred in Minnesota, right? But it wasn't a mistake. The courtroom fell still. Kutira, stunned, blinked rapidly. She hadn't heard from her attorney in weeks. Do you know what this is about? The judge asked gently. She shook her head. The judge looked exhausted. Do you even want this man as your lawyer anymore? What choice did she even have? Her defense had vanished into thin air.
let's proceed to 23 CF 189 for sentencing. Mr. Schmidt, you may begin.
Sure. This is kind of a hard one to do for sentencing, in part because it's a deferred judgment conviction that got revoked for commission of a new crime. The defendant has not been convicted of the new crime. He's presumed innocent of it. Normally what I would say in these cases is I usually go for a probation first when there's revocation of a DJOC, and that's because most of our revocations for DJOCs are for non-payment of fine or them not doing like the programming required on the DJOC. Mr. Stewart's done the programming on this DJOC. So probation, do anger management, DV, that would make sense because he's already done that. I'm going to be asking for some jail time on this. And the reason why has to do with his history. If you look at CCAP, Mr. Stewart looks like he doesn't have much history. If you look at CCAP, you see a single forfeiture ticket in Grantsburg for DC. You see Minnesota, some weird misdemeanors for traffic violations regarding equipment violations in a 2008 DUI, and that's it. When I look at tech, though, I see there have been a lot of charges filed against Mr. Stewart over the year, and I wondered why none of those show up on CCAP. And the reason why is 2019, Mr. Stewart, domestic DC, did a DJOC there, completed it. That's why it's not in CCAP, got dismissed. Did a DPA on another domestic DC in 2017, completed that, got dismissed. Ordinance on a DC in 2014, another ordinance on a DC in 2014, ordinance on a domestic DC 2011. 2005, felony child abuse, DPA completed, dismissed. So there is a trend that goes back 20 years, at least to disorderly behavior, domestic related behavior. That's gone unabated. It also shows that when he's completed numerous DPAs and DGOCs, meaning he's done the conditions without getting in trouble on those. This would be the first one I believe he hasn't. For that reason, I think the court for this, the DGOC wound up being on the misdemeanor battery. I think the court should consider jail time between 3 and 6 months. I think 9 months would be too much because I don't know how much jail he's done in his life. It can't be a lot. I can't imagine he's done more than 10 days jail at a time. So ratcheting up to 9 months wouldn't make sense given his lack of actual criminal history. But I think because I don't see what probation would do in this case. We're supposed to first consider probation. I don't know what need they would actually address because he's fulfilled the programming requirement of the DJOC. I think that we're really about punishment and we're really about like deterring the behavior. I'm hopeful that getting jail.
In the eyes of the court, this was unprecedented. A disbarred lawyer still listed on active cases. The judge was baffled. I don't know how we even got this far, he muttered. He gave her a moment, then leaned forward. If you want a new attorney, I'll appoint one. Katira hesitated, eyes darting around. Could she trust the system again? Would a new lawyer fix what had already gone wrong, or was it already too late?
Conduct ever might deter his behavior better because he's been charged with it and gotten ordinance or DPAs and DJOCs constantly for this sort of behavior. Thank you.
So I guess I missed. How much did you ask for?
I asked for between 3 and 6 months, Joe.
3 to 6 months. All right. Mr. Davis.
Thank you very much, Your Honor. So, Your Honor, while that may be true that he have had deferred cases in the past and successfully completed them, that resulted in no conviction. And so you have to look at the convictions, not stuff that was where he did not get convictions or receive convictions, whether it be an ordinance or deferred. Now, Judge, this is a lot different from those other cases. And
have you tried calling him? The judge asked. Katira nodded. No answer. She had texted, emailed, nothing. The judge leaned back. The state bar should have told us, he said, frustration mounting. Katira was just a name on the docket, but her case was unraveling. No advocate, no guidance, just a judge trying to patch together a broken process. You want to go forward today? He asked. Her nod was quiet, uncertain, but she had no other option.
Poignant on this. We were prepared to go to trial on this. And the issue, first of all, I'll say that this is a serious offense. I think it's a lazy argument to say it's a misdemeanor or it's a low-level felony. Let's just get that out of the way. This is a conviction. This does not bode well on his record. My client is employed full-time, and he will not get business if people start doing searches on him and seeing misdemeanor convictions. That doesn't help him. Or if he wants to switch and go to a company or a different company, this obviously isn't going to be a badge of honor. But this specific situation, so he was building a house, and he has his daughter. It's a separated family. They're divorced. So there's the child, the ex, and he, and they have shared placement time. And she comes over, and every time she's at that teenage age, where she'd have chores, she wouldn't do them. She wouldn't do her homework. She wouldn't help with the chores. She wanted a new house, and he did everything to build this new house on what I call a creek, not a river, but a beautiful home that he wanted to build for he and his daughter, and they were working. And he kept telling her, "Will you start helping? Will you start helping clean up the lumber?" And he did take a piece of lumber, Your Honor, and he did not intentionally throw it at her, but he threw it in her direction, and the board hit her. And he was frustrated parent. He wasn't trying to hit her or smack her or take a board and hit anybody. He's like, "Come on, you just help, start working, start helping with the chores, help me around here. Not just don't come over and sit on your phone or your iPad or whatever it is." Now, yes, he could have tried something different, maybe grounded her or time out, but he threw a board, but he did not.
The court offered her a deal. Resolve the ticket, no contest, no conviction. It was mercy, maybe, or just clean up after the storm. You'll just have a fine to pay, the judge explained. For a woman left legally stranded, it was a lifeline, but the damage had already been done. A silent attorney, a system asleep at the wheel, and now Kutera had to take the hit and walk out of that courtroom with more questions than answers.
Her with it. In any event, he understood that that's not how to handle that situation. He entered into the deferred judgment of conviction, and he did have some requirements to do an anger management assessment and follow through, which he did do, Your Honor. And then I believe he also had another assessment with, I think, parenting and child parenting, and I believe he completed that. What's really tough right now is that he hasn't had much contact with her and hasn't even had so much as seen her in months, didn't see her for the holidays. And now I believe she's moved from Grantsburg School, Your Honor, where she's always gone, and now she's moved to Pine City School. Her grades are abhorrent. Her grades were not doing well in Grantsburg, but I believe they're even worse now. And so I know that children, they like to make decisions. And I know that if you're under 18, you're a minor, you're a child. And it's a lot easier, Judge, I know you've seen this, to be with a parent that gives you the freedom, the video games, that can do whatever you want, and all these things. And yeah, that's nice. And sometimes the parents migrate towards that. And sometimes the parent that has homework time, we sit down for dinner together. You need to help me with some of these projects around the house, and you have chores. Yeah, that's not the fun parent. I know that. I had two parents like that, and there's always a chores, or there's always something. And when I'd see my friends playing or skateboarding or swimming,
she accepted. No contest, she said softly. The judge finalized the deal. Just a ticket, not a conviction. Relief washed over her face, but behind her eyes was a storm of betrayal. A lawyer gone rogue, a courtroom scrambling to adapt, a woman nearly railroaded by silence. Kutera left the courtroom quietly, no headlines, no justice speech, just a closed case, and a disbarred lawyer who never showed. In a system built on defense, she barely had one.